We're ready to begin. If you're here on the immigration bill, you're about 4 hours late. So, in the wrong meeting. This is the Tuesday meeting of the House Judiciary Committee. We've got several matters to consider, and I'm going to exercise a little prerogative I have, which is to maybe take a couple of things out of order. I know we've got our representatives here from the Law Department. Ms. Westmoreland, anyone with you? You by yourself? Okay, well, let me go ahead and bring you up so we can talk about the provision on the, this is actually Richard Smith's bill also. And Richard, Representative Smith, if you come on around, I'm going to take House Bill 41 as the first item of business. And if you don't mind sitting with our Law Department Representative Smith and whether she minds. But she deals with a lot of criminal elements, so she's probably pleased to have a representative next to her. This is the what we refer to generally as a fee bill, members of the committee, and what we are doing is, if you read the summary, we of course had a bill passed last year, which Richard Smith was the primary sponsor on, House Bill 1055. Yep. The infamous 1055. We call it famous. Excuse me. That's right. We changed a lot of fees. We found them when we did so afterwards. There was a couple of things that we wish we hadn't done, but we're trying to come back and correct that. And Representative Smith, with that, I'll open the floor to you.
Thank you, sir. First off, I'd like to thank Chairman Lane for carrying this while the other day in his subcommittee, because I was in the Appropriations Committee. I appreciate that. Yes, sir. This, if there ever was a bookkeeping bill, this is a bookkeeping bill. It just reduces the cost from preparation and recording of transcripts from $10 down to $1. In one area, in line 24, it drops it from 5 to 1, and then it takes the $125 judicial operation fee off of the cost of either a renewal or getting a new notary.
Right. And I'm sorry I didn't have my mics on, but I might just adding to what you're saying, this caused a great deal of consternation in the legal profession because of the cost of appeals went up tenfold, right. Almost tenfold, I should say, $1.50 then, so big increase. I know people I've talked to that have had occasion to appeal during this past year have had concerns about it, and the Court of Appeals and the Supreme Court, to their credit, adopted some rules on the basis of allowing attorneys to prepare records without having to be specifically done through the clerk's office, which was beneficial from a cost standpoint. And Ms. Westmoreland is here on behalf of the Law Department dealing with an issue that also needs to be discussed, and I'll let you talk about that if you would, Mary Beth.
I'd be glad to. Thank you, Mr. Chairman. Mary Beth Westmoreland, Deputy Attorney General with the Criminal Justice Division. This sort of a background, and I apologize to the subcommittee members. By statute, the Attorney General is required to file briefs in all murder appeals, regardless of whether it's life without parole, or death penalty. Thus, the statute also provides that the clerk of the Superior Court is required to provide us with a copy of the record. We're not talking about the trial transcript, we're talking about the record, motions, indictments, jury questionnaires, or whatever. The fee on making a copy of that went from $1.50 a page to $5 a page. That fee comes straight out of our budget, goes straight to the counties. It's a copying cost, that's all it is. I've got a bill sitting in my office for $33,000 right now for a copy of a 6,600-page record, Xerox copy. That would have cost us $9,000 previously. It's now $33,000, and some of the clerks, to be fair, weren't charging $1.50, and a lot of them are not charging $5. But
and that's important. I think you're saying when this happens, a lot of them recognize you're under a statutory duty that has to be done. Yes. By your law department, and they just say, "Here's a copy of the record for you."
There are some that will simply send it to us. There's some that are charging 25 cents a page. We have a few now who are charging $5 a page because it's there. they can do so. And as I said, it comes directly from our budget, and a few more cases of that size, and it will hurt badly.
And what that addresses is a Section 1, members of the committee, which is where we say accused in a criminal case was convicted of a capital felony. The clerk shall likewise furnish, and then underline here, at no cost, the Attorney General with an exact copy of the record on appeal. Excuse me. Now, this is a committee substitute, and we had another prior, quote, committee substitute, but this, the one thing I want to discuss, and I'll bring Ms. Travis in on this, we had under the previous Section 6, if you look under the back page, where you see Section 6 starting on line 29 of the substitute you have, I'm going to read what we previously had. I'm going to talk about this. As we had previously stated, it came out, I think, of committee this way: preparation and furnishing copy of the record of appeal in criminal cases where accused was convicted of a capital felony, comma, unless requested by the law department, comma, which shall not be charged a fee, comma, in accordance with Code Section 5643, per page, $1. Now, I guess I'm concerned that we have one area changed, and I like the idea of saying the suspenders in the belt, in the sense that be sure the clerks understand there is not to be a charge by where you have the fee stated, having also some language addressing that point. And Ms. Travis shakes her head at me like, no, you don't need to do that.
So the prior bill you had, the prior substitute, didn't have Section 1 of the bill in there.
Correct.
And so it wasn't clear that the collection, there would be no collection of costs. And I think that the language that we added, except were provided in, and we specified it subsection B, makes it plain to the reader that the costs shouldn't be assessed against the Department of Law.
Well, we say no cost, so they're going to recognize no copying cost, as opposed to a clerk's fee for certifying a record or whatever it may be as a cost. That's my main question. And I know how people can read things sometimes, and they may not pick it up that way.
Well, the language that was in the prior substitute won't retrofit into the way I've drafted this because of the change I made in Section 1. If you want to be more explicit, one of the questions is there anybody else that is charged this dollar? Is this paragraph 6 even applicable to anyone other than the Department of Law? Because if it's not, we could get rid of it altogether. But if it is,
I don't know if we got anybody here from the clerks cooperative that might want to.
Well, I have, but I only became aware of this in subcommittee yesterday. I don't foresee a problem with it, but I would need to vet it. But I think Ms. Travis is correct.
No one else?
Clear. But if you can make it more clear, we always appreciate it.
Okay.
A well-defined statute.
All right.
And Mr. Chairman, we looked at that, I mean, under 5643B, that's clearly the copy that's provided to the Attorney General's office. That's what it says. Whether you can read 5643A is to apply to someone else, that was when it got a little less clear, perhaps.
Mm-hmm.
And I think the concern was whether you took that cost out, that fee out completely.
Mm-hmm.
Our issue is to be sure we're covered.
Thank you. And is that your Ms. Oliver?
Mr. Chairman, I just want to make sure we're working from 4534S because that's the only one I have in my
the one that we're working from is great. It's 4534S.
I have a question of Ms. Westmoreland and another matter, if I may ask both questions.
Sure. Go ahead.
You may not want to offer an opinion about this, but should the Attorney General be statutorily required to file a brief on every murder case that's not a death penalty case?
And maybe offering an opinion is not a good way to put it, because I won't, but I will just tell you what we have been told over the years, that we have been informed that it's helpful to give a statewide perspective in those cases, and the issues that are raised in life sentence murder cases tend to overlap with the death penalty cases. We're not here trying to get out of doing that. We've done it for years since I've been there, and that may be a totally different issue.
You don't think it's again, this is a question I'm just asking myself whether it's an antiquated statutory requirement at this time.
In some senses, but I do think that at least from what I hear from the Supreme Court, they appreciate having the input. We may be looking, the district attorney looks at it case by case. We see all of the cases throughout the state, and again, it does overflow into the death penalty case.
Mr. Chairman, there's one other matter that I think was a cleanup from last year, and I probably, there's some other people working on this, but on behalf of DeKalb County, I wanted to particularly ask about what we're doing in relation to the state court magistrate court fee issue that's impacted DeKalb so negatively.
Magistrate fees?
Yes, sir. You know, in DeKalb County, which at one time had more dispossessory actions than any government on the face of the planet, there's a discrepancy in the fees. It's pretty dramatic now, where the county is losing a significant amount of revenue by the landlords going to the magistrate courts and instead of the state courts, based on what we did last year. The Senate, I think, took out the good part of a compromise that the House had put together, and I just wondered if anybody's working on that.
There's discussions. Nothing's being worked on, but there are some discussions underway about should there or should not be a modification of magistrate court fees.
I'm for that if there's a discussion goes
but it
forward.
won't be a part of this discussion.
Thank you.
Thank you. Yes, sir.
Just for informational purposes, I know that this is a hot issue that's being discussed within the bar and the bench to try to figure out what's the most equitable way of dealing with it. You've got the concerns over the counties over the loss of revenue, and you got the concerns from many lawyers over the fact that the magistrates court, by its very definition, is supposed to be a small claims court, and they don't want to price that small claims court out of the reach of a lot of folks with smaller cases. So there is discussion trying to figure out how to tackle this new problem while at the same time not slamming the door shut on those small claims that need to be addressed in magistrate court. Yeah, it is.
All right, let's get back on our topic if we can for the moment. And is there anyone who wishes to ask a question of the presenters on House Bill 41? Thank you both for being here, and I don't know if we have anyone else who wishes to speak. There is one, I'm sorry. Mary Beth is on you, sorry. Anyone else wish to address the Bill Clark? I believe you got your name also, HB 41.
They've covered it.
You waved?
The bar in general, I'll tell you, not just the plaintiff's bar, but we're all in great support of this bill. Thank you.
All right, thank you. Anyone else wish to address the committee on House Bill 41? If not, we will close all further public input. It's now in the breast of the committee. Do we have a motion?
Do pass, Mr. Chairman.
We have a motion to pass and second it of the committee substitute, LC 294534S. Motions do pass. Do we have any amendments to the bill? No amendments. Any further discussion on the bill? There being no further discussion, Chair calls for the question. All in favor of passage of HB 41 signify by saying aye.
Aye.
Opposed, like sign. The motion does carry. Thank you.
Thanks, sir.
Thank you too, Representative Smith. I've also got Representative Benton here. We'd like to try and get because I know they're busy with other things. Representative Benton, you're on the Chief's Law, as we call it. There you are, sir. Come on around. Have a seat with us. Happy to have you here with us today.
Thank you, Mr. Chairman.
This will be on House Bill 40. Sorry.
Thank you, Mr. Chairman, members of the committee. I bring to you today a substitute to House Bill 40. We're working on 4517S. This is there's also going to be a substitute to the substitute, but I didn't know which one you wanted to work from, so I'm just going to talk about the generics of the bill, and then we can whatever y'all want to do on that.
All right.
Chief's Law is a bill that would require manufacturers of antifreeze to add a bitterant to the product to make it unpalatable to children or adults, animals,
husbands.
husbands, yes, or representatives or senators, whichever. By its nature, the ethylene glycol that's found in antifreeze is sweet and smells sweet, and so animals try to get to it, and children, if they get it on their hands or get it on a toy that they're playing with and then get it on their hands and put it in their mouth, they don't realize that it is something that can hurt them. Ethylene glycol can cause nausea and vomiting. It affects the central nervous system. Kidney failure, seizures, coma, and in some cases death. They say that less than a teaspoon can be fatal. So there are 14 other states that have already enacted this similar legislation to Chief's Law that requires the antifreeze that is sold in those states to require this bitterant. And what we're trying to do is make Georgia the 15th state. There are 2 other states, and I don't have those down here, that are working on the law as well. So we have a lot of people that are supporting the bill, would like to see it pass. Children's Health Care of Atlanta, Georgia Trial Lawyers Association, the American Academy of Pediatrics. Those are all on that fact sheet that is in your folder to give you some idea of the people that are trying to help us get this passed. Be glad to answer any questions of the committee that as they might have them. I'll be glad to try to answer them.
Let me ask one question. That goes to your title of the bill, Chief's Law. How did it become known as Chief's Law?
The young lady that brought the idea of the bill to me had her dogs poisoned by antifreeze, and the one that died was named Chief, and so we just called it Chief's Law.
Okay. And history-wise, you had the bill last year, I believe, did you not? It
Yes,
came through.
We've had it pass the House twice, had it in the Senate twice, and both times it's died in the Rules Committee. So this is we're hoping the third time's a charm.
I can appreciate that. I've had several. Got one today we're looking at like that. Anyone have questions of the presenter? I think you're, yes, sir.
Representative Benson, we talked earlier about one of the proposed changes that we looked at in the subcommittee. I thought it might be a good idea for you to address your concerns about it in terms of adding the words used, not just sold, but used. You were concerned that we were putting a burden on the ultimate user when we wanted to try to focus on the manufacturers, correct?
Thank you, Mr. Whip. The substitute that passed the committee the other day was amended to, on line 14, to after the word antifreeze, used or was added to the line there. And after we left, I went back and I started reading over the amendment, and it seemed to me that we were putting the responsibility back on the consumer, not on the people. We were putting the responsibility on the manufacturers, but now we were putting it on the consumer as well, and felt like that this was going to be an undue burden because the consumer has to take as factual. If the antifreeze says that it has it in there, then it will have it in there. And so I talked with Representative Jacobs, and he is going to propose another substitute to the bill that takes that language out and adds some language in there that deals with the labeling, that the consumer should be able to count on if the label says that the bitterant's in there, then they should be able to count on that. So.
And that's 4543S?
Yes.
And that's the one you would like for us to consider?
That's the one I would like for you to consider, yes, sir.
Thank you.
Let me, in fact, get Chairman Jacobs to address his proposals on that 4543S.
Thank you, Mr. Chairman. The bill that actually came out of subcommittee and is properly before the Judiciary Committee is 4517S. In looking at a little bit more closely at the bill, I must admit when it came to subcommittee, I thought, well, easy enough. It's been through the House twice. antifreeze, we should be able to just report it out quickly. And then after it passed out of subcommittee, in addition to the issue that Representative Lindsay mentioned, the used or sold amendment that was added to the bill, in conferring with Ms. Travis, we noticed a couple of other problems with the structure of the bill, even though it did pass through the House a couple of times, that needed to be addressed. And so all of those issues are addressed in 4543S. And informally, in my subcommittee yesterday, we brought the bill back before the subcommittee to at least discuss this substitute so that subcommittee members had seen it before we present it in full committee. So what I'm going to do is move to adopt the bill at the appropriate time via committee substitute 4543S. Now, the differences between the two are, first of all, that there actually are about 12 code sections, a part of Title 10 that deals with antifreeze. And in that part of the code, there is a definition of antifreeze, and that definition includes engine coolant as part of the definition of antifreeze. Just generally, engine coolant is part of the definition of antifreeze. Throughout the bill, it says engine coolant and antifreeze, or engine coolant or antifreeze. And so that might beg the question as to whether we meant something different by using the words engine coolant that is not included in that definition in that part of the code. So now throughout the bill, we only use antifreeze. The second thing is that the bill is intended to apply to recyclers, and there is a code section in that part of the code that exempts recyclers from that part of the code. So we have to say that this code section applies to recyclers, notwithstanding the code section that says that it doesn't apply to recyclers. More complicated than we thought. And so that is also done there on line 20 of the bill. Ms. Travis did a little cleaning up and splitting code section B into code sections B and C. The immunity provision in subsection D of 4543S is the same as went through the House previously and has been reviewed by Mr. Clark from GTLA. And then subsection E is a new immunity provision that also has been vetted by Mr. Clark from GTLA. And the issue that was presented in subcommittee, and the reason that subsection is included in there, is that the bill is intended to apply to sellers and distributors of antifreeze as well. However, if the sellers and distributors are selling or distributing a bottle of antifreeze that says on its label that it contains the aversive agent, they should be able to rely on the fact that that's on the label, unless they have actual knowledge that the substance is not in there. So that was a provision that the subcommittee requested be added to the bill and is proposed in 4543S. Again, all of the provisions in subsection D and subsection E of the bill were vetted by Mr. Clark at GTLA, and he can certainly speak to that at the appropriate time. But at the appropriate time, Mr. Chairman, I'm going to ask that the full committee consider 4543S.
So, Representative Benton, aren't you pleased that your bill got sent to judiciary this year rather than the normal course that you've had?
Well, it went to judiciary non-civil the last couple of days.
Got real lawyers here.
Yeah.
All right, so the explanation, anybody have questions of Mr. Jacobs about what he is proposing as to the substitute 4543S? So what we have before you really is 4517S with a proposed substitute. Let me ask you this, Mr. Jacobs. When it came through your subcommittee yesterday, was there a vote taken on the proposal of 4543S?
We took it, because we couldn't formally take a vote, we informally polled the substitute, and it met with the approval of the subcommittee.
And the reason you couldn't
informally
was because it had not been published as a bill to be considered?
That's correct. Although we did put it on the agenda, we made sure that it was advertised on the agenda for subcommittee yesterday, that we would consider a substitute that would be presented in full committee.
All right. Thank you, sir. Do we have others in the audience? I think, Mr. Clark, you've also signed up for this bill. I would ask if you'd like to address the committee.
I'll just be very brief and be glad to answer any questions because this bill has an immunity provision. We've worked with Mr. Benton for the last 2 years and now the third session to get this to where we believe it strikes a very good balance between incentives and deterrence and ultimately liabilities and immunities. And we think this young lady has worked. She's not a lobbyist, but next time I've got an opening, I'm going to see if I can hire her because she's so passionate and honest and sincere about this issue that is important to pet lovers, children lovers all over the state, and I've been glad to work with her.
Is that Ms. Cook? Becky Davis. Oh, Becky Davis. Or we have someone signed up as Amanda Cook. If she'd like to speak to the committee.
I'll just make it brief. I think everything that's needed to be said has been, but at Children's Systems, anything we can do to help.
Who do you represent, Ms. Cook?
Children's Healthcare of Atlanta.
Very good.
Thank
Do y'all see poison cases coming in from time to time with
We do. We see quite a few and a lot of antifreeze, especially in the wintertime.
Very well, thank you. And would you like to speak to the committee as a matter of your interest in this bill?
I would. Thank you.
Come up and tell us who you are and who you represent.
My name is Becky Davis, and I'm just here to kind of relay my firsthand experience with ethylene glycol toxicity to you guys. Chief's Law is, as Mr. Clark said, is very dear to me. When I tell you that my dogs were antifreeze poisoned, it's not like my dogs drank poison and then they fell over dead. It was a very excruciating, long, painful death for one of my dogs. I was able to save one. The other one, Chief, was not so lucky. She suffered the same fate as people do, as ethylene glycol is metabolized the same in people as it is in animals. Ethylene glycol is the toxic component in antifreeze. It takes about 35 to 45 minutes to render its harmful effects on your brain and your kidneys. And as we all know, once those organs are damaged, it's not repairable. By the time that you have been made aware that your animal or your child has got into ethylene glycol, most of the time it's too late to save them. There's an antidote to ethylene glycol toxicity. It's called Antizol. The problem with Antizol is it's very expensive. Actually, it's $600 a vial. I bought 3.
Wow.
Most veterinarians do not stock the antidote because it has a very short shelf life. The problem is when children come in contact with ethylene glycol, most of the time it's treated as the flu or it's treated as food poisoning. It's not easily detected. You have to actually look for ethylene glycol. As we know in the case of Glenn Turner, who was murdered by his wife, who 6 years later murdered a firefighter. And their family is in support of this legislation as well. It took 2 tablespoons of antifreeze to kill my 90-pound German Shepherd. So if a child's toy rolls through antifreeze, that's all it takes to be lethal to that child. Yeah. And if you are lucky enough to be able to save that child, you're looking at a kidney transplant or dialysis for the rest of that child's life, not to mention the brain damage that the child has suffered. Once ethylene glycol attacks the body, the kidneys form oxalate crystals. You go into congestive heart failure. It took about 6 days for my dog to die.
Wow.
And it took 6 days for Glenn Turner to die. And I believe it took 3 days for Randy Thompson to die, because Lynn Turner got a little better at it the second time she murdered somebody.
I'm surprised how little you're talking about as being able to be lethal.
Exactly.
3 tablespoons. Amazing.
Well, Denatonium is the bitterant that we would like to see put into antifreeze. Denatonium was originally approved by the FDA in 1963 as a deterrent for children to stay out of cosmetics and toiletries. There was a lot of childhood poisonings going on and a lot of childhood emergencies with toiletries and cosmetics at that point. The alcohol, tobacco, and firearms actually requires a bitterant to be put into any alcohol-based product. And in most cases, they require specifically that denatonium benzoate be that additive that's put into those alcohol-based products. Denatonium is currently used in like polishes and varnishes, cleaning supplies. It's also used as a deterrent for children not to bite their fingernails or to suck their thumbs. And it takes 1 ounce of denatonium to make 55 gallons of pure ethylene glycol unpalatable, to where it won't be toxic to our children and our pets.
Well, thank you for that information, Ms. Davis. Anyone have any questions of Ms. Davis? We appreciate you appearing with us today and giving that testimony.
Thank you. Thank you for your time.
Is there anyone else who wishes to speak to House Bill 40? If not, we will close off further public discussion. The bill is now in the breast of the committee. I'll recognize Mr. Jacobs.
Thank you, Mr. Chairman. I move that this committee give a due pass recommendation to House Bill 40 by committee substitute LC 294543S.
All right, we have a motion and a second. Any further discussion on the motion? Do we have any amendments? There being no amendments, Chair calls for the question. All in favor of passage on the committee substitute of House Bill 40 signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Thank you. Next, we'll go back to beginning of the agenda. We have House Bill 24, and as I'm the author of that bill, I will ask Mr. Jacobs to proceed with chairing this portion of the committee.
Thank you, Mr. Chairman. The chair calls House Bill 24 the Evidence Code rewrite. Chairman Willard, do you want to present?
Thank you. I will present, if
right.
I may, by staying in my seat. We have before you what is House Bill 24. It is the same as we had House Bill 24 last year, which at that time, to give you a brief history, especially the new members, the bill in the past, in 2009, passed the Judiciary Committee and did not come out of rules in 2009. House Bill 24 of the last session on 2010 was discussed, passed in the Judiciary Committee, came out of rules, and passed by a substantial vote in the House. It was somewhat late in the session. It went over to the Senate. There was some discussion regarding the enormous size of the bill and the need of some senators to have additional time to study it. Although it did come out of the Senate Judiciary Committee, it did not proceed through rules for a vote on the floor of the Senate. Therefore, we're back this year with the bill. I was fortunate enough to ask the clerk to continue with the same numbering, so that's why it is also now this session known as House Bill 24. You have in your file a summary that was prepared by Professor Paul Milich with Georgia State University, who will be here to speak on the bill also, but it goes through and gives you the highlighting of the various changes that have occurred with House Bill 24 from what is the current law of Georgia. And I'm sure Professor Milich can do a better discussion of this, but of course in Georgia we have had what we call the common law evidence rules that have been derived over many years, first from the English law and the English decisions, and now into Georgia law and Georgia decisions, codifying most of the court decisions that were the principal rules that were adopted of evidence, and have now become what is known as our evidence code. As we talk about this, it goes back to the fact that the code itself was adopted in 1868 as part of the Cobb writing of the code, and really has remained virtually unchanged, other than the fact that some decisions through the years have enhanced or modified certain principles of evidence. The House Bill 24 is really taking, does two things. It takes what is we call our model code of evidence, rules of evidence, and codifies and adopts those as being the rules that we will be governing our courts in Georgia after its approval and signing by the governor. But it also recodifies many rules and provisions of evidence that we have throughout the code that we had through Jill Travis and other staff members went through and found what we call the statutory provisions addressing how evidence will be presented on certain governmental documents or other agencies that have to deal with evidentiary questions, and it really recodified all that under the to-be new Title 24 of the Code. And I will at this point ask for those who are going to be speaking on the bill to perhaps, Mr. Chairman, come forward and enlighten the committee more than I'm able to do.
Mr. Chairman, are you going to speak to the two amendments that are in the folder?
I'm
Or
going to have that talked to by
Professor
Millich, and I might come up, Professor Millich, we'll have you first if you might. I might say what we've done in order to have complete transparency. We have taken the bill that you have before you, which is House Bill 24, and this is the same bill that was placed in and came out of the Senate Judiciary Committee. It is the same bill that came through the House last year, so we did not want to make any changes of the particular bill. We'd rather have that come back through and have the committee consider what may be possible changes and why those changes may be beneficial to House Bill 24.
But we did change the effective date, right?
Yes, sir.
All right. Professor Millich.
Thank you, Mr. Chairman. I'll address first of all the changes that are proposed. Again, this is the only changes that are made from what was passed last year. The consensus was, as we reached the end stage of this, that we would track the federal rules of evidence as much as possible so that there would be greater certainty in state courts when they were using that language that was interpreted in other jurisdictions, particularly federal courts. So one change we had to make here was that the federal rules have changed. They have changed the rule. What their rule is 804B3, the statement against interest rule, and that has become effective as of December of last year. So your one amendment here would be to amend House Bill 24 by replacing the old federal rule language with the new federal rule language. No big substantive change here because the new federal rule codifies the 11th Circuit approach on this issue. There was a split in the circuits. The 11th Circuit had basically taken the position that corroboration should be required when anybody in a criminal case wanted to use a statement against criminal interest, not just the defense would be required to do that. So this new rule would basically make sure that we stay with the exact same language as the federal rules at the time of enactment. Now, Mr. Chairman, there is a couple of changes in the language. What happens with the federal rules nowadays is they go through a style committee, believe it or not, whose job it is to change the words to make them more user-friendly and whatnot. And so from the time that this language was generated, there are a couple of changes to the language that you have on Jill's sheet on AM 290989. Should I go over those changes?
Certainly.
On line 5, the word far should be deleted. The language is, it was so contrary to the declarant's proprietary or pecuniary interest. So the word far would be deleted there. And then on line 7, it says, or so far tended to subject. The style committee changed that to, or to expose the declarant to civil or criminal liability. So that would be delete so far tended to subject, add to expose. And then finally, in line 8, that should be an and, not an or.
Okay. We'll take those up at the appropriate time.
Okay. I think that, do you want me to talk about it now, or should we?
The other one?
Yeah, I don't really know.
I could probably address this, Mr. Chairman, if you'd like. And what has occurred, if you look into the current bill, the current draft, which is House Bill 24, looking at page, I can't tell you, 94, lines 324 through 329. History-wise, last year, the Supreme Court had a committee headed by Justice Melton, Harold Melton, and the purpose of the committee was to look at, first of all, some decisions that come through the federal courts addressing when and under what circumstances it's appropriate or it's necessary to have interpreters for individuals who are appearing with limited language ability as far as English. And out of that committee, there was a proposal prepared, and that proposal came forward to this committee. It was inserted as suggested by the Justice Committee on interpreters, and this is what you currently have on lines 3124 through line 3128. This year there has been some discussion, especially with a meeting that was held of the Superior Court Judges Council, and they had some question and concerns about the language under this paragraph B that they felt may require that they could only use court-qualified interpreters. I also had the same question after listening to them, because we did not intend to say that only court-qualified interpreter, means someone who has gone through a testing certification, would be the appropriate and only ones who could, for the benefit of court, make an interpretation. Going back to Chief Justice Melton, after the discussion with representatives of the Superior Court, it was decided to go ahead and eliminate what is paragraph B on that portion and just have the renumbering of the paragraphs C, and I believe also, let me stop, yeah, we've deleted B, we now have C as B, and then you come down to the Supreme Court, which is D, is now going to be C. I'll repeat that for you. What you have under lines, on the current bill, lines 3124 through 3126, identified as paragraph B, would be eliminated. Then on line 3127, you would have paragraph C actually become B, and on line 3129, the paragraph identified as D would become C. So we discussed this with Chief Justice Melton, and he concurred that would be an acceptable change to make, and therefore we have prepared the proposed amendment, which is identified as HM 290992.
Right. Why don't, because the bill has already been through the ringer with this committee and through the entire legislative process and the study committee that existed prior to that, I don't think we need to rehash the provisions of the bill. But if there are any questions for Professor Milich, we'll certainly take those at this time. Any questions for Professor Milich? Seeing none, thank you for joining us here today. It gets easier each time, doesn't it?
Well, yeah.
Tom Byrne, next.
Thank you, Mr. Chairman. I thank the members of the committee for entertaining this very important legislation once again. I think those who have been through the process probably heard enough from me over the years about the bill. I'm one of a long line of people who are involved with the State Bar evidence modernization effort for now 23 years or so. Has to this point been unsuccessful. There are 43 states now. We've added another state that has adopted the federal rules of evidence model for their courts. Illinois became the latest. All of the southeastern states, including Alabama and Mississippi, have long ago adopted a federal rules template, and I think it's not hypercritical to say that Georgia has the most antiquated and worst set of evidence statutes and lore of any of the 50 states. You'll have a chance once again to try to fix that, pass this committee, pass this House last year. Hope very much that you support it once again. This originated as a State Bar proposal, and the president of the State Bar, Lester Tate, is here today. He may have something to add. It was vetted and tweaked exhaustively during 2008, 2009, last year by this body. I see Representative Lindsey nodding. He endured that process with many of you.
The proposal is supported by every segment of the State Bar of Georgia. Every constituency that gets involved in approving legislation has nodded its head in support of this. We have the Bill Clark's group. We have the Georgia various civil defense side organizations. We have the Jack Martin's group, the criminal defense bar. I mean, the unanimity itself tells you that this is a piece of reform legislation that is long overdue. This kind of unanimity among the state's lawyers is about as rare as a albino solar eclipse. I mean, you just don't see it. But the time really has come. The ease of use as a work tool of these rules for lawyers and judges will lead to much greater predictability, much more efficiency, and better justice really for all Georgians. So again, on behalf of the State Bar Committee, I urge you to once again endorse this legislation.
Chairman Willard.
Mr. Chairman, let me mention, I think it's the follow-up of what Mr. Burns said. He's chair of the Evidence Committee for the State Bar that proposed this, but one of the interesting things I felt, talking about Illinois, it was actually the state of Illinois that began a process about 30 years ago by adopting what was then to be a new set of evidence rules, modernizing, we'll say, what they currently use, which was the common law evidence, as they are also a common law state. Now the full cycle has occurred. They've come back around, and through what has been established as the model rules, they've now adopted the model rules. So I think it's interesting to note that that is a process that occurred. And it's important also to realize, ladies and gentlemen of the committee, that these rules are to have a impact of what I consider to be possible errors that have been caused in trials and hearings of cases that I think, Professor Millis, you know of one I'd ask you just to briefly tell about that caused a reversal of a criminal case because of the issue of our rules not being in a better state of form because of the common law rules.
Yeah, the case was out of Cobb County. It was a road rage case several years ago. This was a case in which a woman was driving on a two-lane road. She sees this man come up, get right on her bumper, starts flashing his lights, honking his horn because he can't pass her. So he's giving her obscene gestures, and finally he starts to pass her, and he throws something out the window that hits the side of her car hard enough to dent it. Well, she's scared to death, but she did get his license number. So she calls the police, and she gives them the license number. The police officer runs the license number, finds it's registered to a certain woman. He goes to the address, knocks on the door. The woman's mother answers the door and says, "No, that's my daughter's car. She doesn't have it today, my son has it." "Well, is he here?" "No, he's not here." "Well, here's my card. You have him call me when he comes in." 30 minutes later, the officer gets a call from the defendant, and he says, "What's this about?" He says, "Well, were you driving down I think it was Highway 41, Cobb County?" "Yeah, that was me, and then that woman, she wouldn't get out of my way, and she was driving too slow, blah, blah." Well, he gets arrested. He goes to trial. He didn't testify. The officer does. The victim does. The jury convicts him. Goes up to the Court of Appeals. Court of Appeals has to use our evidence rules and apply them faithfully. And in the process, they say, "Well, hey, we have a problem here. You didn't properly authenticate the phone call, that was actually the defendant on the phone." Why? Well, partly because Georgia's laws with regard to authentication of phone calls is pretty old-fashioned. Keep in mind, the statutes were written before the telephone was invented. So obviously it's not a good fit there. And so from the failure to authenticate the phone call, the court moves to the fact that means that the caller's statement, "That was me on the road," was hearsay. Well, there was no objection to hearsay at the trial, so everything's okay, right? Not in Georgia. We're the only state in the entire free world that allows a party to basically not object to hearsay, but then come back on appeal and object at that level. And so Judge Blackburn, writing for the court, said, "I'm sorry, we have to throw this conviction out." So two old, archaic rules basically led to a reversal of a conviction. Now, of course, the victim was probably told that it was technicalities that led to the conviction, and we're all lawyers, we understand technicalities are sometimes important, but not these technicalities. These technicalities are not important. There's not another state in the union that would have reversed the conviction on that record. So those are the kind of real-world consequences that we run into, and that I read about all the time, because I have to read every single evidence case in this state every year, that we run into all the time because we're still using these 19th century rules. Thank you very much.
Thank you.
All right. Any questions for Mr. Byrne? Thank you
for
very
coming
much.
today.
It's good to see you again as well. All right. Next up will be Lester Tate, President of the State Bar.
Thank you, Mr. Chairman. I am here today to urge your passage of this bill. The State Bar, as I look around this room, has been urging passage of this bill for a long time. And in fact, the room sort of graphically illustrates it, because when Rick Crawford and I were in high school together, the State Bar was urging that this bill be passed. We both were fortunate to graduate from high school, me by virtue of social promotion. But years later, I went into law practice with Representative Lindsey, and the State Bar was still trying to pass the evidence bill. I have now been gone from Atlanta and practicing law in Cartersville for 20 years, and the State Bar is still trying to pass the evidence bill. And for many, many bar presidents before me, I always tell folks I'm fortunate to represent 42,000 lawyers. If we added up all the lawyers that have supported this bill in the many years that we've tried to pass it, I probably represent millions of lawyers sitting here today. But it is probably, of all the things that I have seen in my years of being on the Board of Governors, serving as an officer in the State Bar, the only thing, as Tom Burns said earlier, that there's been this kind of unanimity of agreement about. And when you look at the committee that we had, the desire to keep this to be a relatively neutral bill, where different sides weren't trying to game it for their own practice or for their own benefit, it's been a tremendous effort. It's been a good effort. It's been a very unifying effort for the bar. But frankly, I'm glad for it to be over, and I hope we get this bill passed this year. There are three people that I want to thank profoundly. One of those is Professor Paul Millich, who's provided the technical expertise, and the other, of course, is Tom Byrne, who I think has been every bit as enthusiastic as Chiefs owner was in trying to get this bill through, and with what he's done. And finally, Mr. Chairman, Representative Willard, the State Bar just has no greater friend than you. And there was a time when I've been in meetings with the bar officers that we thought it was time to, with regard to the evidence bill, figuratively go up to the top of the embassy and take the helicopters and leave the country, because we weren't going to get it through. But because of your diligence, Mr. Chairman, and your hard work, I'm hoping that it won't be fool's gold for me like it has many other State Bar presidents in the past. And so I urge you to pass it. Thank you.
Thank you, Mr. Tate, and certainly appreciate all of the State Bar's support of this project over the years. And finally, Jack Martin, representing the Georgia Association of Criminal Defense Lawyers.
I signed up just in case there might be some troubling amendment, and I understand what Professor Millich is doing. That's fine with us. And on behalf of the Criminal Defense Bar, we support the bill. However, if y'all think it might help for us to oppose it,
Thank you, Mr. Martin. Anyone else to speak to House Bill 24? Oh, I'm sorry. Majority Whip.
I do think it's important to also note and to thank Mr. Martin. He was one of those individuals who was there for the 4 or 5 months that we went over this bill every Thursday, and I do thank you for your involvement.
All right. And anyone else speak to House Bill 24? Yes. Yeah, absolutely.
My name's Robert Stokely. Is there other information I need to give you before I speak?
Are you representing anyone?
I'm representing myself and my own interests.
Okay. You may testify.
Thank you. I'm very proud that Professor Millich pointed out the fine work that me and my fellow misdemeanor prosecutors do. We don't often get much attention in such a environment as this. I think that there could be a lot of distinctions made about the example he made. And I think the Court of Appeals ruled properly there because you can't verify who was on the other side of that phone. The problem there, though, is that's like saying there's a pothole in Peachtree Street and let's just rip it up and throw it out and just have another road somewhere else and do away with Peachtree Street. The arguments I've heard made that this is a 1860s evidence code, I think we all know better than that. It may have originally been drafted in 1860s, but it's been reviewed thoroughly many times by our fine appellate courts here in Georgia. But if we want to go with that, then let's do away with the U.S. Constitution that's even older than that and start over there. I don't think you can base what we're going to do based on how old something is or that it's got specific problems. I think you've got a bigger problem in Section 1 of this bill where it calls for the federal courts now to be determinative of what our rules of evidence would be. I don't know when our state wanted to invite the feds into helping us run our court system in any part of our state. I could give you something to worry about, and it might sound a little bit about, the boogeyman's coming to town, but how would we like to have the Ninth Circuit of California, who ruled one nation under God cannot be used in the Pledge of Allegiance in a school, telling us how we view evidence? I don't think we want to do that.
But that's not what the bill says.
Well, I think
The
it does,
bill
sir.
requires the courts to look to this circuit, the 11th Circuit, not the 9th Circuit.
Well, I guess the old saying applies here. When there's one lawyer in town, he starves to death or she starves to death. There's two that make a living, three get pretty well off, four do really great. So lawyers tend to disagree, but the bill says where conflicts are found to exist. So if the 11th Circuit hasn't addressed the issue, my reading of that would be the 9th Circuit or some other circuit could be the controlling law on this issue. That scares me, especially when I see some of these other circuits, and I'm a very conservative person, so I don't want the 9th Circuit of California telling us how evidence is going to be in Georgia. I really don't want the feds telling us at all. I believe we do fine as a state, and I believe if we got specific problems with our state evidence code, let's address the evidence code and not throw it to the federal wolves, as I call it. Now, with all due respect to my colleagues at the state bar, and I respect their hard work, and I respect the long view they give to this, the membership of this has never voted on this bill. And I don't know how many of you have ever had calls to your offices or emails demanding that something be done. It's in a state of chaos out there. I bet that's not the breadth of what you get complaints about as committee members. I bet it's not the breadth of what the whole House of Representatives or the state Senate or governor or anybody else in the state gets a qualm about. I think there are many other issues that you probably get, emails and calls about that are of much greater concern, and I doubt that if you counted the number of lawyers in this state and got their vote on it, that you would have a large majority of them saying, we got a problem. But we've got another issue here we need to address, and that is finances. Is there a fiscal note on this bill, what it's going to cost local and state governments alone to comply with it? There'll have to be extensive retraining. There'll have to be repurchasing of materials. How much will the future litigation cost arguing over what it means versus what we've already litigated? And why are we going to dump it back on our appellate courts to be the final arbiter when we're taking the federal rules? It seems to me we'd say federal courts rule, that's it, no talking about it. Or we'd say, no, the state courts rule. But how do you balance that interest there when a state court of appeals or state Supreme Court's going to say, well, the feds have said this and we're bound to go by it? We're essentially stripping our own state appellate courts of the ability to look at this unless it's mere dicta somewhere. I think there's a lot of financial concerns here. As a prosecutor who has to run a small office with shrinking dollars, where do we get the money from? Where do the private attorneys get the money from that, in this day and age, clients already can't pay their bills? How are they going to charge more to come into training and compliance on this law? Where are the clients going to get the money to pay for that? Who's going to pay for the millions of, maybe hundreds of millions of dollars of litigation costs? I mean, Has anyone done a fiscal note would be the question I would ask, and I've not heard of one. If there is one, I'd love to see it. Maybe it would allay my fears of this bill. But there's a cost to this. Nothing's free. And I think we ought to address that before we address what the fix is. But if we're going to go forward with this, one particular area of the bill I would urge you to consider today is the mileage provision for witnesses. While it raises it from 20 cents to 45 cents a mile, it leaves it in the position it's been in the last 30 years for the next 30 years that it would take legislative action to change that. Right now we're paying 20 cents a mile, which is a 1980 mileage rate. I would urge you that if you're going to do anything regarding mileage, and I'm not saying if you did something with mileage, my other concerns would be assuaged, but if you're going to do something regarding mileage, make it a floating mileage rate that tracks what we as government employees get reimbursed, which is the IRS rule that applies. Not set it at a fixed standard and leave it there for the next 20 or 30 years and become an unconstitutional taking of citizens' money who are compelled to come to court and testify for the state or for other private parties. So those are my comments, and I appreciate being able to come forward. Thank you.
All right. Thank you for your testimony. Anyone else to speak to House Bill 24? Yes, Mr. Malden, District Attorney from Athens, correct?
Thank you, Mr. Chairman and Vice Chairman. As I said, I'm Ken Malden. I'm the District Attorney in Athens and happen to be the President of the District Attorney Association of Georgia. And I was not down here last year when this was being worked over the last several years, but did come down on occasion. I understood, of course, the prosecution community had a number of concerns as it's gone through, as some other folks did also, and that as it came out of the House last year, a number of those concerns were addressed. And as I've expressed to the chairman before meetings we've had and otherwise, that it's the position of our association that we're not in a position to oppose it at this time. We're not, I can't tell you that everybody's in full support of it, nor could I offer that at this time, but that's something that we've actually taken action on, that we understood there were some concerns. We understood that they were addressed as best they could be at that time, and we stand really with that same position we had before. And I understood the concerns Mr. Stokely has had, but I think that's the position we have at this time. Thank you.
I appreciate your stating that for the committee. Anyone further to speak to House Bill 24? Mr. Fortner.
If I may, Brian Fortner, I'm the solicitor of Douglas County, and I'm on the legislative committee for the Solicitors Association. I wanted to thank the chairman and Chairman Jacobs for allowing us to be here once again to speak to the evidence code. We've been involved since 2008. It's always been an open door policy. We were told that any prosecutor who wanted to be a part of the study committee could come. I know because I was there every time we met on all of those Thursdays throughout 2008. As many of you know, we had very strenuous objections. When we have those, we're not afraid to make them, and we made them during the course of the vetting of this particular bill. And as of last year, we had some concerns. We met with the parties involved, and we were able to work out compromise language that led to us withdrawing our opposition in the bill at that time. I speak for the Solicitors Association and tell you that we no longer oppose this bill, and this is the same bill, I've reviewed it, that was dropped last year as House Bill 24, and there have been no changes that I've found other than the amendments we have spoken about, which were actually discussed last year because we knew that those changes were coming as far as the 804B3. So I just wanted to reassure that position with the chairman and be here in case the members had any questions about that.
Thank you. Any questions for Mr. Fortner? Seeing none, thank you for your testimony. All right. Any further anyone else testify to House Bill 24? Seeing none, we'll close off testimony. The bill is now in the breast of the committee. And I'll recognize Chairman Willard for a motion.
Mr. Chairman, I'm going to move passage of House Bill 24, and once I have a second, I will have a discussion, also some comments, if I may, please.
Okay. There's been a motion by Chairman Willard, a second by the majority whip, so the bill is now before the committee. We'll open it up for discussion. Chairman Willard.
I would like to just respond a little bit to my friend Mr. Stokely in regards to I'm probably one of the older lawyers here. I don't know if the oldest, not the older lawyer would call it. And I go back many years, and when I first started practicing law, we were beginning a process called the Civil Practice Act. You talk about a major change in the way you run courts and how you handle civil litigation. The Civil Practice Act was a whole new book. And prior to that, you had the demurrer systems. And we didn't take a vote in the bar, and it was a major change. But everybody understood that it had to be done because it was bringing us to a better system. We also had back then negotiable instruments, and that changed because we adopted what was the Uniform Commercial Code to bring us in line with other states in this country. A substantial departure from what we were doing, but we didn't take a vote on that either. It was a matter of what was in the best interest of the state from an economic standpoint and also from a business standpoint. I can go through, I guess, title after title over there in my years of practice, whether it be the guardianship code that we changed under Ms. Oliver, under the trust code we did last year. Is a need from time to time to bring laws of our state into compliance, and whether it be recognizing uniform laws or a better practice and way of handling civil matters or criminal matters in the courts. I suggest and state to the committee that what you have under House Bill 24 is that type of standard and that step in the direction of making our state a more user-friendly, we'll call it, as far as parties in litigation, whether they be within Georgia or coming to Georgia as part of a civil matter or criminal matter, to have recognizable and used rules throughout the country. I would ask and urge support by the committee. I would like to at this time also, Mr. Chairman, if you're ready to propose 2 amendments to the LC 294445.
We'll get to amendments in just a second. I just want to see if there's any further discussion from the committee on House Bill 24. Seeing none, we'll close off discussion. Any amendments?
Mr. Chairman, I would like to propose amendment that the committee would look at AM 290989. This is the amendment as to the provision referenced by Professor Millich dealing with the statement against interest. I would propose that, and I would ask also to have the following provisions of AM 290989 modified or further amended. First, let me propose the amendment, and then I'll offer the amendments to the amendment.
All right, we'll take up the amendment first. Is there a second on the amendment, AM 290989? There's a motion and a second. Any amendments to the amendment?
Have a proposed amendment on line 5, Mr. Chairman, to strike the word "far," so that we read, "It was so contrary to the declarant's proprietary or pecuniary interest."
Is there a second on that amendment to the amendment? All right. Any discussion on that amendment to the amendment? Seeing none, the chair calls the question. All those in favor of the amendment to the amendment say aye.
Aye.
All those opposed, no. The amendment to the amendment carries. Any further amendments to the amendment?
I have a further amendment to LC 290989. On line 7, Mr. Chairman, I'd like to strike the phrase "so far tended to subject" and insert instead "to expose," so that it will read, "a claim by the declarant against another or to expose the declarant to civil or criminal liability."
Is there a second to that amendment to the amendment? There is a second. Any discussion on that amendment to the amendment? Seeing none, the chair calls the question. All those in favor of that amendment to the amendment say aye.
Aye.
All those opposed, no. The amendment to the amendment carries. Any further amendments to the amendment?
Mr. Chairman, I have a further amendment to LC 290989 at line 8.
AM 29.
AM, sorry.
All right.
AM 290989, yes, sir. At line 8, to strike at the end of that line "or" and insert in its place "and."
Is there a second? There's a second on that amendment to the amendment. Any discussion on that amendment to the amendment? Seeing none, the chair calls the question. All those in favor of the amendment to the amendment say aye.
Aye.
All those opposed, no. The amendment to the amendment carries. Any discussion on the amendment as amended? Or any further amendments to the amendment?
Yes,
amendment?
Sir.
Oh, there
Mr.
is.
Chairman, I'd like to offer another amendment.
Okay, hold on. There's no further amendments to the amendment. Any further discussion on the amendment as amended? Seeing none, the chair calls the question on the amendment as amended. All those in favor say aye.
Aye.
All those opposed, no. The amendment as amended carries. AM 290989. Any further amendments to the bill?
Mr. Chairman, I'd like to offer an amendment.
All right.
You have in your folder AM 290992. This addresses the provisions on page 94 at line 3124 through line 3129. And what we're changing, Mr. Chairman, is we're striking under the proposed bill what is currently the paragraph B in its entirety. Then we are changing the lettering of what is now paragraph C, making it B, and on line 3129, making D C. I would propose that as an amendment.
Is there a second? There is a second. Any discussion on that amendment? Seeing none, the chair calls the question. All those in favor of AM 290992 say aye.
Aye.
All those opposed, no. The amendment carries. Ms. Travis. Can you pull the number one mic around?
On page 15, line 480, the code section should be subsection.
Okay, page 15, where?
Line 480.
Okay,
subsection.
of this subsection, semicolon, and, correct?
Correct.
Someone want to propose that as an amendment? Is there a second? All right, any discussion on that amendment? Seeing none, the chair calls the question. All those in favor of that amendment say aye.
Aye.
All those opposed, no. The amendment carries. Any further amendments to House Bill 24? Seeing none, the chair calls the question on House Bill 24, LC 294445, as amended by the House Judiciary Committee. All those in favor say aye.
Aye.
All those opposed, no. The bill moves forward with a due pass recommendation. Want to do the other one?
Yeah.
All right.
Number 30.
All right. Chair calls House Bill 30. This is the non-compete enabling legislation. We'll let the room clear out on the evidence code. Oh, and I should recognize Judge Lawton Stevens.
Yes, I'm sorry, Judge. We missed you.
And Judge Billy Ray.
Oh, yes.
Oh,
There
and
she
Kathy Goslin. Thank you all for joining us.
What a nice crowd.
I'll lose a quorum.
Yeah.
All right, we're going to proceed with House Bill 30.
Get that door.
Someone over on that side of the room make sure that the door gets closed.
There we go.
Thank you. All right, we're going to proceed with House Bill 30. Chairman Willard, if you'd like to speak to the bill.
Thank you, Mr. Chairman. Let me explain to the audience and also to members of the committee. House Bill 30 is actually what was House Bill 173 in the year 2009. This is what we call our Restrictive Covenant and Employment bill. And the history of it is, I see our citizen Levitas is here today, former representative, member of this body, and glad to have you with us. He was the primary sponsor of the bill, did a yeoman's job, very diligent in the work we had to do on this bill. The purpose behind it was to try and clarify in Georgia something that's always been I guess best way to describe it, mercurial issue, that is how to draft a contract dealing with restrictions of employment, either during employment as well as post-employment, And the bill was vetted very much during 2009. We decided to go ahead and proceed with the bill, although that would require a constitutional amendment, and that was to be done in 2010. But the idea was to place before the legal profession and the business community what we would have as a structure of law in this area that the state Supreme Court had found to be previously unconstitutional. I won't go into the history of that, but that was based upon what we have as a very strong provision in our state constitution to deal with the right to work. So we did pass the bill in 2009. The bill, as passed, recognized its enactment date would be upon the approval of a constitutional amendment by the voters of Georgia. We then, in 2010, worked on the constitutional amendment resolution. That resolution passed the House, it passed the Senate, it was on the ballot in 2010, and it passed. The problem developed after passage of the constitutional amendment, recognizing the fact that our constitutional amendment, as we put it through this body, did not have an enactment clause stated as a part of the amendment, meaning that there was nothing there saying when the amendment would become force and effect as a change in our state constitution. Because of that, we now had a bill that would become a law as a recognized statute in Georgia upon its being approved by the voters at the referendum. But the constitutional amendment did not become effective upon that approval. It only became effective by exercise of another provision in our state constitution that said that constitutional amendments, unless addressed otherwise, will become effective on January 1 following the general election when the amendment's approved. We think, well, okay, we did have a little problem there. We'll just go ahead and recognize the law will then become effective on January the 2nd. However, we have case law in Georgia where similar issues have been addressed by our state Supreme Court, and the state Supreme Court, in speaking on the subject, said no. If a statute becomes effective and there is not supporting constitutional provisions for that statute, it is void, and it is void ab initio, which means it cannot be revived even by amendment of the legislature later. So when you have that facing us, it was felt the only conceivable way that it can be rectified, unless we wanted to wait for several years for the Supreme Court to try and address it and then perhaps find the same thing I'm telling you, the way it would be rectified is to have the statute itself go back through this legislative body, the General Assembly, and be signed by the governor as a new enactment with the supporting provision of our state constitution. With that background, Mr. Chairman, we have prepared what is House Bill 30, and you have before you LC 294456. This is the same bill and statutory provision that was approved and passed by the General Assembly in 2009, save and except for some minor, I call them tweakings of the either punctuation or paragraph assignments, and that was done by Ms. Travis, who was not the original drafter of this bill, but using her great talents to vet out problems in legislation. She found some things that she felt needed to be clarified. There's nothing changed, though, as far as the intent and the essence of the law that was passed. So that is what's before this body at this time. I may add, it's just a final comment. I have had, I should say, several individuals addressed to me, and I know we got some representatives here from the business community that I'd like to ask them to also speak to this program. I'm still struggling with some language that it deals with the provisions under sections 13.856 on page 9. You have two statutory provisions addressing these restrictive covenants. One is the limitations of restrictive covenants, what we call during term of employment. That is under 13-856. The next section is 13-857, and that deals with the restrictive covenants of employment post the term of employment of an individual, meaning that you're now separated from your employer. You had a contract of restrictive covenants, and the contract addressed restrictions on your further employment and services after you leave the employment. And the questions that has been raised by several people is the fact that the language under 13-856 speaks of things during the term of the employment, specifically paragraph 2B, which is the agreement contains a list of particular competitors or as prohibited employers for a limited time after the term of employment or a commercial or business relationship. We had some discussions. I know we've gone over this. I want to talk some further about it, but that's the only thing that I've had come forward that had any concern with attorneys who review the particular language, but we can talk about that.
Any questions for the author? Seeing none, we'll take testimony on the bill. I've got two folks signed up to speak to the bill. David Rayner from the Georgia Chamber of Commerce and Erica Berg.
Thank you, Mr. Chairman. David Rayner with the Georgia Chamber of Commerce. I appreciate the opportunity to be here today, and we certainly appreciate the leadership of Chairman Willard on this issue. If the committee recalls, over the last 2 years, the Chamber has actually been a major proponent of this legislation and the subsequent constitutional amendment that did pass overwhelmingly by the public vote of 68%. I think it was the leading vote getter for any constitutional amendment on November's ballot. We feel that now that the law and the constitutional amendment are in place, it will place Georgia on a level playing field with other states in protecting both employers located here in Georgia and then others that seek to locate here in the state. So basically, the businesses now, we feel, have a sense of certainty when it comes to these employment agreements. So we applaud the committee and this body for their efforts to see that this got passed over the last 2 years. So did want to introduce Erica Berg with Seyfarth Shaw, who's here today, who's actually an area of expertise in this area to address any questions of the committee, and also talk a little bit about where we are now in the process, what she's seen as the issue that the chairman's pointed out in this legislation. So,
Ms. Berg?
Thank you very much. And again, I'm Erica Berg with Seyfarth Shaw, and I'm not here on behalf of the chamber, but here as an attorney who practices in this area and who has watched this bill since 2008. In particular, with respect to the timing issue, I just wanted to address, I'm not certain that you absolutely need to address the timing issue, but applaud your efforts to do so. As an attorney who represents clients in this area, I urge you to do so quickly, as many businesses are still uncertain as to what their rights are, and we have courts who are now faced with potentially having three realms of law to apply, the common law for agreements that are before January 1st, the current bill as it stands now, in the future. So it is a matter of some importance to the membership. As to 13-856, I think there's a misunderstanding, at least when I read the bill, as to what it is intended to address. As you look at it, the phrase during the course of an employment relationship, that is one of two places where the word course is actually addressed in the bill. And if you read the entire portion, that cannot be read to be equivalent with during the term of a relationship. I don't think anybody during the entire course of drafting, as I sat and listened to this committee and others, ever intended 13-856 to be limited to those agreements that were made for interim, so from the moment that the employment relationship started to the end. If you read 13-856 to be interim only, it would actually read out several provisions in it. I think courts, seeing that there is potentially conflicting terms, can only read 13-856 to apply both to interim and to post-term covenants. So, the concern here is do you change that language, and if you do, what other issues do you address? I think you could actually leave this issue to our courts. I think it's one of a matter of interpretation of what you've done. It's a good bill. If you start tweaking the language, you're going to create, again, you've got this tripartite system where you've got the common law. You're going to have whatever happens for those agreements that were entered into January 1st to the time you enact this bill, and thereafter, creating additional confusion. So I actually urge you to let the courts address that issue, because I think there's a reasonable interpretation that can be made under 13856 for the way it stands. And I'm happy, again, I consider myself a little bit of a law geek in this area, so I'm happy to answer any questions about what we're seeing in the bar and the discussions that folks are having.
Well, I won't refer to you as a law geek.
It's okay. I refer to myself that way. It's all right.
Questions from Ms. Berg or Mr. Rayner? Any questions? Seeing none, thank you very much for your testimony. Les Schneider.
Members of the committee, my name is Les Schneider. I'm with Wimberley & Lawson, and I'm an attorney who practices in this area quite a bit and was involved when this thing first started. My suggestion is to make a change, to clarify exactly what the chairman talked about, so there is no confusion. On 13856, the concern I think some people would have would be the fact that we talk about on lines 292, when we're talking about a time period not to compete or not to be restricted, a time period equal to or measured by the duration of the party's business or commercial relationship is reasonable. And I know I spoke to Representative McKillop and I've talked to the chairman. Nobody had any intent of saying that after somebody left the employment of the employer, if he had worked there, if he or she had worked there for 20 years, that we were going to restrict that person as to scope and geographical limitation for a 20-year period. But since, as the chairman has correctly noted, that in the part of the bill on line 299, we talk about, on 299 and line 300, we talk about a limited time period after the term of employment. Now, the scope and the geographical limitation would apply both during the time of employment and after the time of employment. The time period of which they couldn't compete or couldn't solicit is the major difference. And I guess this is what I would suggest to the committee to consider. On line 290, if after the word during, you add the phrase or after, and then on line 292, you begin with the parenthetical phrase, during the course of employment, comma, a time period equal to or measured by the duration of the party's business and commercial relationship is reasonable, and then after the semicolon indicate the reasonableness of a time period after the term of employment shall be governed by OCGA 13857, which when you turn the next page, it's clear from 13857 that if you're just an employee and you don't have any interest in the company other than employment, then you basically, a court shall presume to be reasonable and interest restrained 2 years or less, which is on line 328. I think if you do this, you are going to remove all doubt that there was clearly the objective is that we were going to set different time periods after a person left the employee of the company as opposed to during their stay at the company. And I think that language would help the judiciary make it clear that we have a roadmap that both employers can follow, employees can follow, and the courts. And I think that language will remove all doubt on that particular issue. I know, Chairman Willett, I know we talked about this yesterday and provided that information. I do think it further clarifies the wording on that issue. And I wouldn't want a court to come back and say, well, the way we read this, the scope and the geographical limitation is not going to apply after somebody leaves the employee of the company. And I would respectfully submit if that language could be added, I think we're further strengthening the bill.
Questions for Mr. Schneider? Seeing none, thank you for your testimony today. Anyone else to speak to House Bill 30? Mr. Chairman.
Let me ask, if I may, for Mr. Rayner and Ms. Berg, is it? would y'all come up and let me speak to you about these points? Do you see that there is anything that may be looking to a court who has had before them now an agreement, and they're trying to address what was the legislative intent under this Section 56, that what is being suggested is appropriate or inappropriate as far as trying to make any changes?
I don't think that the changes that Mr. Schneider is talking about are contrary to the legislative intent when they first passed the bill, and I do think that they're clarifying. The question then remains, what else do you change, right? There's the issue there. Do you have to change it to make it clear? I don't think so. Is his language slightly better? Perhaps. But is it necessary to achieve the same meaning? I don't think so.
Well, that's more. We're sitting here in a committee room, hopefully doing the right thing with what we're going to pass. Now we leave it to the courts to look at it and say, legislature intended what by this particular provision, and do we need to make anything as a change that will be giving better guidance to the courts as to what that intent is?
You know, certainly, I think it's clear because you can't read the statute to be solely as to in-term covenants. I don't think you can read 13856 that way, pursuant to the rules that the courts are to apply as to the statute itself. Does adding or after, as Mr. Schneider suggested, improve it? I think it does. Do I necessarily agree with the time period? I don't know. I haven't vetted that particular section, and that's not one that's come up to me in my conversations with my clients or others as being a problem. But if you added or after, during the course or after, you might want to say during the term or after to make it consistent with the other places in the bill. But I don't think it's necessary to do that. If I can, ride that fence a little bit. I don't think you have to make it clear, but is it an improvement? Potentially, yes.
Potentially could improve it. I like that.
Thank you for that definitive answer. Any other questions related to this topic? Seeing none, thank you for coming back up. Anyone else to testify to House Bill 30? Seeing nobody, we will close off discussion on the bill. The bill is now in the breast of the committee. Is there a motion?
Mr. Chairman, I'd like to make a motion.
Mr. Chairman Willard.
I would move the committee approve House Bill 30 under LC 294456.
Okay, there's a motion. Is there a second? Okay, there's a motion and a second. Any amendments? Well, any discussion on the bill? Seeing none, Chair will entertain amendments. Any amendments?
Chairman, do we have proposed amendment in writing?
I don't have one in writing. I think Mr. Snyder read out. If you want to have him read it out again.
Mr. Schneider, why don't you come forward and read it out again?
What you did.
And we'll see if someone wants to actually move your amendment.
On line 290, after the word during, you would add the phrase or after. And then on line 292, after the one, you would insert the phrase during the course of employment.
How about during the term of employment? It has the same term.
Because that's what's used above. But
I think keep the same terminology.
During the term of employment, a time period equal to the measured duration by the parties business commercial is reasonable, semicolon, and then add the reasonableness of a time period after the term of employment shall be governed by OCGA section 13-18-57.
Can you repeat that last part one more time? And it has to be code section, whatever it is, per Ms. Travis.
The reasonableness of a time period after the term of employment shall be governed by code section 13-8-57.
Ms. Travis, do you have any stylistic points on? Why don't we just, because there we go.
Governed by what?
Code section 13
That's where you get the 57. Or 58. You're right, 58. Reasonable recipient. The term is fine.
I want to be sure Ms. Travis gives that a stylistic vetting.
Doesn't. I don't like that.
The other phrase is one.
I don't want that.
Representative Crawford.
May I lend additional confusion to this discussion?
You may.
If I'm understanding this correctly, what we are seeking to do is clarify the proposition that 13856 is intended to apply for a situation where there are covenants applicable during a term of employment. In other words, while the employee is still in the employment relationship, while 13857 would govern any restrictions on what that then former employee could do after the term of employment has ended. Is that correct? I'm just as a general observation. Is this the point that we're trying to address?
If I may, I think, unless you may agree with me as well, 13856 was never intended to apply solely to interim covenants.
If you can pull your mic to you, Ms. Berg.
13856 was never intended to apply solely to what we would call interim covenants. Those are the covenants that start when you join somebody and end when you leave, to say that you can't work for an employer who competes with me during that term. It applies to both. And the use of the words during the course was meant to be both before and after, but was perhaps inartfully said. So I think what Les is suggesting is that you're adding during or after, and maybe changing the course to the term of an employment or business relationship will clarify that we mean to include both interim and post-term covenants. Well, I think you can make the argument to a court that you don't need to do all of this. If you're going to do it, that would be the way to address it. But 13856 applies to both as to various things. 13857 only applies as to time periods. So there's a special provision regarding the time periods, which is an element of the restrictive covenants.
I think further support of that is line 300, where you see the word a period of time after the term of employment. But I think the joint concern is that, and because this is clarity, if you add in all the words I think that I have suggested, then there is not going to be any question that after the term of employment, there's going to be a certain time period which is set forth in 13857. But the scope and geographical application, as Ms. Bird correctly indicates, must apply both during the term of employment and after. And that's why we're discussing the detail to avoid that confusion.
So in essence, then, the distinction isn't whether it's during or after. The distinction is length of time versus the other considerations.
Well, you're right. The length of time, no one in the committee or no one during this process ever suggested that if I've worked for a company for 20 years, while I'm working there, I may be restricted by scope and scope of work and geographic limitation, but also the whole time I'm working there, even if it's 20 years, I'm not going to compete or solicit my existing employer's clients. Now, once I leave, we can't apply that 20-year rule that if I work there for 20 years and I leave, then I'm going to not compete and not solicit for the next 20 years. That's why 13857 is very clear that the time period is presumptive only 2 years. I'm just trying to make that very clear, that when somebody leaves, we're not trying to impose a restriction of time equal to the time they've worked for.
So, and I get that point. So what I'm leading to is this. Is it not reasonable to conclude that to the extent that that might be a matter of confusion, it is generated by the language of subsection 1 beginning on line 292? When we have all this language talking about a time period equal to or measured by the duration, so could we fix this just by reworking that language to clarify that we're only talking about while the employment relationship exists?
And that's what, obviously, maybe an argument, but that's what I attempted to do, that during the term of employment, as Chairman Willard indicated, the time period would be measured by the duration of the party's relationship during that time, but that the reasonableness of the time period after the term of employment is going to be governed by 13857. Because, again, geographical limitation and scope is going to be the same during both, but the time limitation has to be different. You're correct, Mr. Chairman. If we don't do that, the concern is that somebody may say it's unreasonable to tell somebody that if they work there 20 years, that once they leave, they're going to have to do it. So that was the intent to do that.
Mr. Chairman, may I be recognized?
Yes, Chairman Willard.
Ms. Berger, I want to express what I'm going to say as a legislator. I want to try and keep this thing from becoming a problem. And my fear is if it leaves this chamber here as far as this committee and gets over to the Senate after we pass it on the House side, these same occurring questions are going to rise again. And I'm fearful that it gets over there with the questions arising again. There may be a difficulty in trying to control what's going to happen with it in that body. Now, I wonder if you are open to the idea of you sitting down, and maybe Mr. Snyder too, with our legislative council and seeing if, as you say, yes, there may be a way of perfecting the wording here by doing something that would be understandable, that we find to be less than understandable at this point in time.
Certainly.
And I was going to suggest what we'll do, if the chair would entertain, is table this until the next meeting for that purpose, which would be Thursday.
All right. What I'll do is just suspend consideration of House Bill 30, and the chairman can put it on an agenda for a subsequent meeting. So we're going to hold the House Bill 30 for a subsequent meeting of the House Judiciary Committee.
Yeah. And one last point to this is my intent is this, just to be clear to everyone. I want it to come out of this committee and prepared to go forward through both chambers as quickly as possible without anything delaying it, and get it before the governor. And I've talked to the governor's people, and he will be, I'm told, prepared to sign it as soon as he sees it. So we can clear this all up. I know there's a lot of lawyers out there and a lot of businesses. I talked this morning to the Franchise Association, and there were 4 or 5 people that talked about this very point who say, no, we're trying to decide what to do. A lot of people are just living with uncertainty on that.
Thank you.
With that, I'll turn the chair back over to Chairman Willard.
Thank you. I think the one last bill we have left is your bill, is it not?
It is.
Calendar. The Uniform Interstate Deposition and Discovery Act. We will call for it on House Bill 46, and Chair will recognize Mr. Jacobs.
Thank you, Mr. Chairman. House Bill 46 is the Uniform Interstate Depositions and Discovery Act, We've had this bill before the House Judiciary Committee before. In fact, last legislative session, it made it all the way to the Senate Rules Committee, but didn't make it out of Rules and onto the floor of the Senate. The version of the bill that you have in front of you is exactly as it passed out of the House Judiciary Committee and all the way through that process last year, with the exception of the effective date. What the bill does, and this goes to the idea of making things work better and more efficiently when we have an opportunity to do so, is that currently in civil cases in which there is already an existing Uniform Act on this subject, and in pursuant to that Uniform Act, in civil cases where, in out-of-state civil cases where discovery is needed inside the state of Georgia, you have to have a commission or writ from the out-of-state judge in order to obtain discovery in Georgia. The current Uniform Act also only applies to depositions, so you can't obtain discovery inside the state of Georgia in an out-of-state case using the Uniform Act to obtain documents or to obtain inspection of premises, inspection of land. The new Uniform Act would greatly simplify and streamline the process so that all you would need from the out-of-state case is a subpoena. You could take that subpoena to the clerk of and that's a subpoena from the out-of-state court. You could take that subpoena to the clerk of court here in Georgia and obtain a subpoena for the discovery that you need. In addition to that streamlined process, the new Uniform Act applies not just to depositions, but also to paper discovery, obtaining documents, and to inspection of land as well. In addition, whereas you need a lawyer in Georgia under the old Uniform Act to bring the writ from the out-of-state court or commission from the out-of-state court here to Georgia and obtain your subpoena, in this new Uniform Act, there on lines 41 and 42, it does not constitute an appearance in the courts of the state to take a subpoena from an out-of-state court and present it to a clerk here in Georgia, which means that you do not need a lawyer to obtain your domestic subpoena in the foreign case. And finally, this is a departure from the Uniform Act as it came to us. Well, actually, there are two departures from the Uniform Act as it came to us from the Uniform Law Commissioner, on which Representative Lindsay, the Majority Whip, serves. He's one of our 3 Uniform Law Commissioners from Georgia. One departure was that in the House Judiciary Committee last time around, this was an amendment by Representative McKillop. We made it so that the domestic subpoena has to be issued in the court where the person or entity from which you are seeking to obtain discovery resides, so that they would be able to challenge the subpoena in their local jurisdiction. And then the second change that we made was to actually import the existing Uniform Act into the new Uniform Act, so that if there are lawyers who, without reference to what the new law is, do obtain a commission or writ from an out-of-state court, they don't bring it here to Georgia and then are turned away at the courthouse saying you can't obtain your subpoena here in Georgia in this out-of-state case because we don't take commissions or writs anymore because the legislature changed the Uniform Act. So this is actually both the old Uniform Act and the new Uniform Act in one. There's really no reason that if you obtain a commission or writ from an out-of-state court that you shouldn't be able to obtain at least your deposition here in Georgia. And with that, Mr. Chairman, I would commend House Bill 46, the Uniform Interstate Depositions and Discovery Act, to the full committee.
Thank you. Any questions of the presenter, members of the committee? If There being none, is there anyone in the audience who'd like to speak to the proposed bill, House Bill 46? If not, we'll close all further discussions from the audience, and it's now in the rest of the committee. I would have one question, that is dealing with the uniform laws. As I understand them, there will only be, what's the word, lost the term, recognizing
comity.
Comity, thank you, between the states who have also adopted this provision of the uniform laws.
I believe that is correct, Mr. Chairman.
Do we know how many states thus far have done so, and if there are neighbor states?
Last time it was, I think it was 14 last. I have not checked on the new number, but I will get that before I present the bill on the House floor. Okay. There have been additional adoptions since we last had the bill before committee. I'm relatively sure of that.
And I might add, Mr. Chairman, that Uniform Law Commission has certain push bills that they do urge every year, like 4 or 5 bills that we really would like everyone to pass. This is one of those push bills we're trying to get as many states as possible to pass, knowing that it will make practice of law a whole lot easier for folks who have to practice across state lines.
I have experienced myself in the past problems getting things from other states, or certainly getting someone to take a deposition.
Depending on how quickly the foreign court moves on your subpoena or writ, your writ or commission, it can take quite a long period of time. This is definitely an improvement on existing procedure.
Thank you. Any further discussions among the committee members regarding this bill? If not, the chair is open to motion. The move to pass House Bill 46 as submitted, and it's been seconded. Any further discussion on the motion? Are there any amendments to be presented? There being none, the chair will call for the question. All in favor of approval of House Bill 46 signify by saying aye.
Aye.
Opposed, like sign. Motion carries. That is the last scheduled item we have. I do have one other thing before you leave. I would ask you to at least think about this. This is just something left over from last year. The case of Patricia Parker versus Alan Beneke. Is there anyone who has an interest in taking up this issue this year? If you don't remember the terms of it, this is dealing where you had the tolling of a statute of limitation, where you have, in the case of, the court recognized in the case of someone having violated rules of the road, that rises to the level of criminal prosecution. There is a tolling of the statute until that case is resolved. I know we had some discussions with the plaintiffs' bar, the Georgia Trial Lawyers Association. I thought we had something worked out, but nothing ever really finalized. I forgot what happened as far as the ultimate bill, but what did it never came to the floor of the House? Do you remember?
Yeah, I believe, Mr. Chairman, it didn't get out of the rules, but this is a we have to figure out a way to fix it. Either attach it to another bill or
I'd rather do it as a standalone, but does anyone want to take on this issue for working with the other sections of the bar?
I will.
Mr. McKillop. There's the volume of cases and information sent to me by former Judge Alan Blackburn, who had, I think, wrote the decision, was involved in it. He had issues about it too. All right. There being nothing further to come before the committee, we will stand adjourned. Thank you for your attendance and time today. Oh, you're right on top of things, you know.